Okay, good evening everyone. Welcome to the week 8 tutorial. This week we'll be talking about consumer protection and mostly we'll be focusing on the Australian consumer law, which is a really important subject. And in fact, some of you are probably doing the Australian consumer law unit in its own right as well. So you'll be very familiar with some of these topics, but for the rest of you, this week is aimed to give you a good overview of some of the really important points. So this evening, what I wanted to do is to briefly touch on a little bit more about the second assessment and how to do well. And really what I'd like to do is focus on your critical analysis. The other thing that I'll be doing, I've been asked if I could put a practice question from a previous year up on Moodle. So I'll be doing that tomorrow in addition to tonight's recording. I'll put a practice question on from a previous year that you can have a go at answering as well. But for now, I just wanted to talk a little bit more about critical analysis because that's, I think, a big area for improvement. And I think I talked about it last week as well, but it bears repeating because it is so important. And what I'll do with the first problem for today is actually try and show you guys some examples of an answer that perhaps isn't so great on critical analysis, and then an answer that does more to show in more concrete terms what I mean. But broadly, what we're talking about here is sort of at the one end of the spectrum in terms of an answer, towards more of the pass end of things. We're thinking about, can you apply the law? Well, can you identify the law and the correct law, obviously, and then can you apply that? And that's, if you can do that, you're good for a pass credit, depending on how well you do it and things like that. But then when we get to sort of the other end of the scale, in terms of your distinctions and your high distinctions, what we're looking for, one is a more nuanced application. So considering a few more of the quirks and details that arise in the facts is really important, but also being able to identify counter arguments is really important. But doing more than that and actually being able to synthesize those different arguments and those different nuances and quirks. It's obviously really good if you can say, look, here's a particular client and this is what they'll argue, or this is, an interpretation of the law and the facts that suits their claim. Here's probably what the other side will say. And that's, could be a strong argument or it might not be. And it's really good if you can identify that counter argument. But what a really good answer does is it's able to actually synthesize those two perspectives together. You're not just saying, well, it could go either way, and I guess we'll just have to wait for the court to decide. You can actually weigh up the strengths of those two arguments and point to what about those two competing arguments is particularly strong or weak. And obviously there are no certainties. You wouldn't be saying definitely your client would win or definitely they would lose, but you can point to aspects of the law and aspects of the argument that lead you to say, well, yes, there is this competing argument out there, but we wouldn't expect that to be supported, and instead probably a court would favour this interpretation instead. And what you're doing when you do that is you're showing to me as a marker, yes, I understand the law really well, and I'm showing you that I really understand that because I can evaluate which arguments are stronger and which arguments are weaker. When you just say, well, it could go either way, what you're saying to me as a marker is, well, I kind of get it, but I'm still not quite sure. And obviously, there's room for a tentative conclusion, or some element of tentativeness. But generally with these kinds of questions, you shouldn't be sitting on the fence. You should be able to lean one way or the other, at least to a degree. And it's in supporting that conclusion, that you show me the strength of your knowledge and your understanding. And that's really important. And that's critical analysis in a nutshell. So I'll try, and the other thing that's probably a feature, actually, I'll save that for the example. So I won't talk about that just yet. Question in the chat, are we still doing template answers? No, I'm not going to be giving up full template answers like I did in the first half, because the expectation is now you have a better understanding of what I'm expecting from you in terms of an answer. So I won't put up full template answers for these later topics, but what I will do is I'll put up snippets like, so for today, I've got sort of two examples of part of an answer, one that does critical analysis and one that doesn't really. And so I'll upload that and you can compare the difference. So I'll upload parts of answers, but not full answers for these later weeks. So that's critical analysis. That's what I'm really looking for in your answers. So that's a skill to be practicing as we go through these workshop problems as well. So with that in mind, before I talk about the first problem, are there any questions about the content or the Australian consumer law stuff that we've talked about? No, that's good. Something that might be useful to you as well in thinking about ACL problems is there's a temptation in all of this law, but I think it's especially strong with the ACL because, the terms do really leap out to you. There's a temptation when you read a set of facts to jump really quickly onto, oh, that's misleading or deceptive conduct. Oh, that's bait advertising. And usually that instinct is quite correct. But what it can be helpful to do is take a step back first and look at the facts, obviously, but identify, well, what's the problem in sort of real terms here rather than necessarily in legal terms. And then once you've done that, then start to look at, okay, well, in a legal sense, what does that start to look like? Because you can sometimes find, and if we get to it, we might see some examples of this. If you start with, oh, well, that's clearly unconscionable conduct, you can actually lead yourself to miss out on some of the other smaller provisions. Whereas if you start with the facts first and start with actually, okay, well, from a consumer's perspective here, someone who doesn't actually know the ins and outs of the law, how would they frame the problem? And that can actually be a really useful way of starting to grapple with, okay, well, because the law is trying to protect consumers. So starting from the consumer's point of view can actually be a really useful way of getting to the, I guess, the rationale for the law, and then from there identifying the provisions. Just make sure that you're not missing anything, which can be quite useful. So with that in mind, let's look into problem one for this week, which says that there's an advertisement placed on the internet that purports to offer nominal fees for access, free software, a free modem, and free software installation. And it also states that conditions apply. There's no mention of the large annual registration fees and prepayments, and that payment by credit card is required. Is that conduct likely to contravene the Australian consumer law? If so, in what ways, and what remedies might be available? So where did you guys start with this problem? What, as sort of a bit of a brainstorming exercise first, what things leap out to you?
My first question, because the question was specifically about the ACL, my first place was, does the ACL actually apply? Because the facts don't indicate whether the advertisement is targeted to consumers or if this is a small business. So I want to know a little bit more about, the parties.
Yeah. Cool. So does the ACL apply? What else? or we can start with that. We know that this is on the internet, this ad, and so there's potential for anyone to see this ad, right? Yes, there's an important distinction of if this is targeted at small businesses who might not be covered by the ACL, as they're not consumers. What we need to know, and this sort of comes to your point, Mo, is a bit more detail about what this product actually is, right? In terms of advertising to the public at large, what we're interested in is, out of all the public who would see this ad, who's most likely to be affected by the conduct? So who's most likely to be buying this product? And that's from Valve Corp. So in this case, if the most likely purchasers of this product are small businesses, then we might not be too concerned. But if the most likely purchasers are some type of consumer, then perhaps we are looking at the ACL applying. So perhaps we can proceed on that basis, assuming that this is a product that's targeted at consumers. The fact that there's a modem included suggests that this is some kind of internet package, perhaps. And so perhaps that's being purchased in a domestic context. Is there anything else that we might be interested in terms of who might be buying this product? So even if we're assuming that this is a product that's most likely to be purchased by consumers in a domestic context, we also might want to consider whether there's a particular type or class of consumer that this is being targeted. Is this something that's being targeted towards people who have a sophisticated understanding of computers or tech, or is this targeted more broadly? And what does that tell us about the kinds of things that people of that class know or might be expected to know about purchasing things in this context? And again, that's something that's a little bit open on the facts. You might say that given that it comes with free software installation, you'd expect technologically savvy people to be able to do the installation themselves. And so that might lead you to think that, okay, maybe the target is not especially advanced in their understanding of computers and software, or the software itself is fairly basic, like an antivirus software or something like that. But obviously you do need some more information in that regard as well. But if we proceed on the basis that, one, this is probably targeted at consumers because it's advertised to the public at large on the internet, and two, the free installation leads us to expect that maybe this is targeted at not necessarily especially computer savvy consumers, what then are our next steps? What are our next thoughts, do you think?
Sorry, I'll jump in again. Maybe what impression this advertising provides. I'm trying to avoid, because to be honest, I would just jump straight into the ACL and look at what protections apply, but applying a different process and trying to be a bit more logical, taking your advice from before. Well, what's the problem? What impression is this advertisement giving the target audience? And that will then lead you to, well, then what protections may that be contravening?
Yep. So what impression do we think that this is creating? if I said to you, hey, I've got this great new product to offer you, just a small fee, free software, free modem, we'll even install it for free. How great is that? There's some conditions, but you want to buy it, don't you? What impression does that create?
I think it gives a deceptive idea on what nominal fee is and how much you, like how regularly you have to pay it. When you consider the later comment of large annual registration fees, that's not a nominal fee according to the normal definition. So I think that's pretty misleading.
Yeah. So the impression that the ad gives us is, wow, this is a great deal. You get a bunch of free stuff, and the actual cost that you have to pay is quite small. When in actual fact there is this sort of hidden large registration fee. The credit card restriction is there as well, but the big sticking point is this large annual fee that isn't mentioned in the advertising, right? And so there's this gap between the impression that is created for a consumer, which is this is a good deal, you only have to pay a small amount of money, versus the reality, which is this is actually quite expensive and is expensive every year. Yeah. So that sort of in real terms, that's the impression, and that's the problem, is that there is a gap between what is being advertised and what the reality is. And so then you've started to touch on that starts to sound a little bit deceptive. And so now we can probably start turning our attention to the ACL. When we start to think about something being deceptive, what are we thinking about?
Misleading and deceptive conduct under Section 18, or specific false or misleading representations?
Yep, absolutely.
Section 29?
Yep. So misleading or deceptive conduct being the big one. And then also, yeah, potentially false representations as well. So thinking about misleading or deceptive conduct in particular, what's our thought process? What are we looking for from a more legal perspective then? Is misleading or deceptive defined in the Act?
No, it's not. We have to turn to the case law, and that's something that the court will determine. And there's quite a lot of, precedent around the sorts of conduct that could arise to a misleading or deceptive outcome.
Yep, absolutely. So what are some of those factors or principles that are that might be relevant here, do we think?
Well, one of them is whether it's likely to lead into error.
Yep. And do we think that this would be likely to lead into error? If the impression that it's creating is you get this for a small fee, and the reality is different from that? Do you think that that's going to be leading people into error?
It'll lead them into error if there's no place where the conditions can be read.
Okay, yeah. So we're suggesting that that if the fact that it says conditions apply perhaps should alert them to, well, you're not getting the full story here and you need to have a look at a bit more detail.
Yeah, I'd usually say, because that's how a lot of things, like even with Apple, when they change some of their terms of service and use agreements, it's most people skip it, but there's a lot of important things in there. As long as it's available, they can say, well, you're accepting the conditions if you use it. But it really depends on how they run it. If it just says conditions apply, and the only way you can get those conditions is if you go out of your way to give them a phone call and ask what the conditions are, then that's not really a reasonable method to get the information for what the conditions are. You'd have to have the conditions basically right before you have to pay for anything or use it.
Interesting perspective, because it relates very closely to ACCC and TPG, the case. Did any of you get a chance to look at that case?
I didn't, unfortunately.
No, that's all good. I know this is a busy time in the semester, term, I should say. So what's interesting about TPG was, and broadly the facts are similar here, in that TPG was advertising home internet or home broadband for from $30 a month. And then in the fine print, they had, well, in order to get this, you need to have a home phone line, which will cost you another $30. And then on top of that, there are a bunch of other charges and annual fees and subscription fees and stuff that came on top of that as well. And that was all in the fine print. But the trial judge and then the Court of Appeal overturned it, and then the High Court went with what the trial judge said. Said, well, that's not really fair. Customers shouldn't have to go looking for this stuff. They shouldn't have to go searching for the truth. It should all be there in front of them, because TPG tried to argue, well, you know, customers should be doing their research and finding out all the rights and obligations under this contract before they sign it. And the court said, no, you can't expect people to go digging for this stuff. It needs to be all clearly laid out in front of them. And so that, I think that aligns quite closely with what you were saying, James, about, you know, if it's there, then perhaps it's a bit more reasonable. But if you have to go looking for this stuff and the facts seem to say that you do have to go digging a little bit, then that's perhaps not okay.
It would be like reasonable opportunity or something. I'm not sure what the terminology for that would be.
They didn't really speak of it in those terms. They just, the quote, sorry, jump in.
Yeah, I was going to say, wasn't it in the realms of adequate disclosure of information in regards to internet fees? For that case, they basically said that a failure to adequately disclose the material truth of the fees that applied amounted to being misleading.
Yeah, so I mean, the interesting quote from the trial judge was that the ads required consumers to find their way to the truth past advertising stratagems which have the effect of misleading or being likely to mislead them. So the advertising strategy was designed to make it hard to find out that there were all these extra costs. There was the ads were designed to make you think, oh, great, I can get internet for only $30 a month. That was the dominant message. And here, we've potentially got a similar scenario where the dominant message is there's only a small fee and you get all this extra stuff. And the reality is hidden, and consumers have to find their way to that truth. What I might do, unless anyone else wants to weigh in on anything, is I'll share my screen, and I'll show you two different answers to just this section, this discussion about whether the conduct is misleading or deceptive. And my aim here is to show the difference between an answer that is still technically correct but is quite descriptive, versus an answer that is more critical in its analysis. And what I also want to do is show that that critical analysis doesn't have to come at the cost of blowing out your word count. You can actually be very critical in a shorter space. So I'll just share this. So this is the first answer. And what I might get you to do is just have a quick read through, and maybe just, take some notes as you go through on your thoughts and observations. And then just leave a little notation in the chat to let me know when you finished reading, and then we can have a quick discussion about that one. And then we'll have a chat about, and then we'll read through the second answer as well. And so I'll be uploading this as well after the tutorial for people who are watching this later. So can you guys read that okay? You don't need me to zoom in more?
It's fine for me.
Cool. Excellent. Okay, so what did we think of that answer? Initial impressions.
I mean, it's a decent enough answer, but I think they went a bit overboard with the direct quotes to get that they didn't need quite that much information to get their point across, I guess.
Yeah, absolutely. And this was something that I noticed a little bit in some of the first assessment reports, was some fairly chunky direct quotes of laws or judgments. And I mean, it's good because it shows me that you've clearly read it, and that you can identify it, or this is relevant. So it's not wrong to put this stuff in, but it's far better to paraphrase that stuff, put it in your own words, and then you show me that not only have you read it and you understand that it's relevant, but you actually really understand how it applies and how it operates and what the key message is. So yeah, the big quotes from section 18, the quote from Campbell, and then the quote from TPG really eat into a lot of words, and they don't, above a certain amount, don't really tell us all that much. Yep, absolutely. Anything else?
No, just a bit horrified that I picked up on some lines used in there that I know I use in some of my answers. So yeah, a bit of reflection.
It's not all. I mean, you'll see in the second answer that I used some of the same lines twice, so it might not all be bad news. But perhaps some of the structuring, it steps things out quite logically, but perhaps there's a little bit too much stepping out. You can sort of cut to the chase in a little bit more detail in some places.
With this one, they overquote it. They're quoting the stuff they really don't need to hit. It's more along the lines of quoting what the actual piece of law that you're trying to say is. But did we really need to know that it was only $29.99 a month? No, it really wasn't the point. The point was TPG was going to get them to pay something.
Yeah, so
it was $30 a month doesn't really get your point across. It's just showing that you read the case, and it's already assumed that you read the case if you're referencing it. So
yeah, so sort of perhaps the emphasis isn't quite on the right things, and same with providing the direct quote of section 18. Yes, it's a block quote and it eats up a lot of words, but it also, given that misleading or deceptive isn't actually defined in the Act, quoting the section doesn't really put the emphasis on the right thing. The emphasis needs to be on the discussion around misleading or deceptive is conduct that leads a person into error from Campbell. Yeah. So we might, unless there's any other thoughts, we might move on to the second one. So note as well, just over 400 words for just discussion of that issue. So let's have a think about the second, an alternate way of approaching this answer. Cool. Okay. So comparisons between the two. Well, I guess first, do you think that this is a better answer?
To me, it flows a little bit less, but it definitely hits a lot harder to the points.
Mm-hmm.
As in my last thing, the $29.99 thing is a lot more prominent as to its usefulness.
Yep.
It's outlining the point of the $29.99 is it's outlining what's that sort of the double $29.99 is erroneous and misleading. So that's where that is useful as opposed to just knowledge. Quite like that.
There's the difference between here I've shown that I've read the case and here I've shown that I've read the case and I know how to use the things that were raised in it in this new setting to understand this new problem. Yeah, absolutely. Anything else?
think it's really impactful the way that it weaves in what the alternative argument may be and then weighs up the merits of the arguments in a really succinct way.
Yep. So it's acknowledging that, whereas, you know, in the first answer, it's just, well, the court would follow TPG and it would be misleading or deceptive. And it's sort of, you know, end of story. Whereas in this one, scroll too far, you know, the acknowledgement of the competing arguments, because, you know, the company's not going to take an accusation of misleading and deceptive conduct lying down. They'll have their own perspective. But being able to demonstrate, well, this is what they'll probably argue, and this exact same argument has already been rejected before, helps us evaluate and synthesize those competing perspectives. Yep, absolutely. Any other thoughts on that one?
For me, it was lacking just a little bit in the lead into the topic. Like, I found it in the first one. It's jumped straight to the idea of when advertising can be misleading or deceptive, or, you know, conduct or enactment. It doesn't really start with sort of as a result of the, like, I guess it just me, it's lacking an introduction. It could just be because it's a part answer, but it just
absolutely.
seems like it starts from nowhere.
So yeah, so there's to both these answers, there's your sort of your pre-discussion about, well, what are the issues, and also would the ACL apply here? But yeah, you guys are right that there is perhaps a little bit more scaffolding to be done in this second answer, but you notice as well that we're, you know, 50, 60 words under what the other answer was. So you can actually add a little bit more scaffolding in. I probably tried to push the envelope a little bit too far, but still come in with using fewer words than in the previous answer. So yeah, a bit more of a lead in. But the other thing is taking out all those block quotes, which you guys identified as being problematic. Really what that's mostly given us room for, one is to acknowledge the competing argument, but also to include a discussion about, well, what does nominal actually mean? And if you know, depending on the length of the rest of your answer, you could actually expand that even further and actually say, well, maybe there's an argument to distinguish TPG here. In TPG, they were quite clear about, you know, the dominant message was, well, this will cost you $30 a month. And that was misleading because it didn't cost $30 a month. Here, nominal, you know, we expect it to mean small, but it's a bit more ambiguous. You know, one person's nominal is another person's large fee for an internet or another service. So there's perhaps a little bit more room to argue. And so one, being able to acknowledge that as a potential area of discussion is important, could probably be expanded upon as well a little bit more. But taking out all those block quotes alone gives us room to be able to discuss those types of nuances in the facts. But there's also, and you know, it takes practice, there's a skill in identifying that as a particular issue as well. And that's why it's really important to be paying attention to the nuances in the facts, but also to have a really good understanding of the law as well as it relates to those facts. Does that make sense? Any other thoughts or observations about either this answer or comparing between the two? Okay, so I'll stop the screen share. We've identified that this is probably going to be misleading or deceptive conduct following TPG. What do we think the potential remedies would be?
There could be injunctions under Section 232.
Yep.
To stop, to cease the advertisement, or alternatively, it could be interim while the whole matter's being heard.
Yep. And who would be pursuing that, do we think?
Well, an action could be brought by a regulator like the ACCC, or someone could privately bring an action as well, potentially a competitor.
Yep, absolutely. So what's interesting about the consumer law is that it doesn't actually rely on a party having suffered damage yet in order for an action to be brought and for something to be done about the conduct, right? So, in this set of facts, we're not dealing with, Steve bought this internet package and has been hit with all these fees that he wasn't expecting. What can he do about it? The facts don't even tell us that, but presumably this is before consumers have actually been affected by this conduct. But the ACCC or someone else can jump in even before then, which is really useful in a lot of these scenarios. It's worth probably noting as well that I think that sometimes with these sorts of things, there would be a temptation to argue under Section 224 that a pecuniary penalty would be applied. But that wouldn't apply here because this misleading or deceptive conduct falls under Part 2-1, but that's not listed under Section 224 as the provisions that a pecuniary penalty can attach to. That covers unconscionable conduct, and then the other actions around unfair contract terms, things like that, all the things in Part 2-2. So just, I guess, a quick note that Section 224 wouldn't apply to this one. Any questions about that one? I should open the chat just to see if there are questions. No? Cool. Alrighty. Let's move on to the second problem, which is quite brief. A corporation is in the business of providing casual administrative staff to other businesses. So that's what they do. They advertised a series of job vacancies in order to expand the pool of available employees. But actually the corporation had no jobs waiting for applicants. Advise that corporation. So what's going on here?
This one I just jumped straight into the provision of the ACL and I went to Section 31, misleading conduct as to employment.
Yep. Tell us more.
Sorry, I just had the ACL up because I just made a couple of quick notes. So essentially that provision, it relates to a person, which a corporation is, that they must not, in relation to employment, engage in conduct that is liable to mislead persons seeking the employment. And I found that the relevant part of that was the availability of the employment. So this corporation is holding themselves out to have these jobs, assuming that the ad is actually saying these are jobs available as opposed to register to be a part of our agency, then that's likely to be a contravention of Section 31 because it is misleading. It's likely to lead someone into error around the fact that there's a job that they're applying for when in fact there is no job.
Mm-hmm. Yep, absolutely. Spot on, pretty straightforward. There's not a lot to that question really, unless someone else has noticed something that I've missed. But yeah, it's pretty straightforward. There was
like an expression of interest.
Well, yeah, and I think that the only sort of potential argument around this is to say, well, you know, this is an agency that basically links people up with casual jobs. They're not actually providing the employment themselves, and so they might try and argue, well, you know, we're not actually providing employment, so we're not bound by that section 31. But you'd have a tough time arguing that, because under subsection A, it specifically refers to the availability of employment, and this is advertising directed at people who are seeking employment about the availability of employment. It sort of doesn't matter that they're not the ones actually offering that employment. And then subsection B is any other matter relating to employment. So that's even broader. So I think you have a very hard time arguing that this wouldn't be a breach of section 31. But, you know, maybe people who are watching from home, if you want to post something up on Moodle, if you find something. But this one, yeah, pretty clear cut. So what I thought we could do, I'll just find it. If we circle back once again to the coronavirus, I saw this ad. It's from Germany, but let's just pretend it was here in Australia. What do we think might be potential issues with this advertisement? Can you guys see?
Yeah. Well, it's sort of implying that it will completely protect them against the coronavirus.
Yep. So we've got an ad here saying this face mask will protect you from the virus. Yep.
Which is completely incorrect, since the face mask stops you spreading the virus, it doesn't stop you contracting it.
Yep. So, you know, when we look at the medical evidence, that all points to the face masks really not doing all that much to stop you from getting it in the first place. So what if we tie that back to the ACL? What does that start to sound like?
Like it might lead you to error.
Mm-hmm. Yep. So it's creating this impression in the consumer that, you know, if you buy this, you'll be fine, and you won't be. So there's that gap between what's the impression it creates and the reality. Yep.
I don't even think you could argue puffery with this one, because the advertisement looks quite serious.
Yeah, it's not. You'd sort of it's a claim that I think is not so outlandishly, you know, wild that you take it as sales puff. Yeah. So misleading and deceptive conduct leaps out to us. Are there other provisions or problems that we think could be relevant here as well? And see, I think this is why, sort of at the start when I was talking about, well, if we identify the problems or what's going on here, that sort of helps set us up for identifying all the issues. Whereas if we latch on to one of the sections straight away, it can sort of blind us to some of the other potential problems as well. So we've identified misleading and deceptive conduct really quickly. If we sort of take a step back here, what else might be going on that might be important or problematic here?
Is there an issue under the consumer guarantees around that fitness for purpose? Like here we're saying that the purpose is that this mask is going to protect you, whereas we all know that it won't. So is there an issue there?
Yeah, potentially. So sort of arguing that this is sort of being held out as something, a product that will work for a particular purpose. And so, it doesn't, it's not going to stop you from getting coronavirus. And so potentially that's an issue. The difficulty is that sort of the stuff under Section 55 more applies at the time of sale rather than necessarily advertising. You can certainly draw the two together, and in the sort of taking the transaction as a whole, an advertisement that creates an impression about the purpose and the fitness for that purpose that then leads to purchase. You can certainly take that all into account, but the sign itself alone might not be necessarily enough. But yeah, certainly under Section 55, fitness for purpose might be a problem. Yep. Anything else? Sorry, I've missed something in the chat there. So false representation under Section 29 as well. Yeah, potentially. So the representation around this will stop you from getting coronavirus. Where is it? Section 29. Yep. So, and in particular, it's in connection with the promotion of the product, and representing that it is to a particular standard, quality, value, or grade, potentially. Yep. What else? That's not right. And it's cut off a little bit down the bottom. Does the advertisement that it's available spark concern in us at all?
I guess it depends on whether it actually is available, or if it's like Australia 4 weeks ago where you couldn't get any sanitizer or masks anywhere.
Yep. So there's potentially a concern with bait advertising if there's not enough stock to meet demand. Usually with bait advertising, we're also concerned with the price that it's advertised at, which the ad's cut off on the side, but there doesn't seem to be a price, but maybe bad advertising. The other thing, if we think about the people who are seeing this ad and who would be affected by this ad are presumably very concerned about coronavirus and racked with worry and everything. Does that potentially put them in a state of vulnerability, do we think?
Could it be like coercion? Some way, is it?
No, probably not quite coercion.
Fear-mongering?
What I was sort of trying to get at there was unconscionable conduct, in terms of there's, people are desperate to do anything that they can to stop themselves from contracting the virus. And so we might argue that that puts them in a vulnerable state where, and we've seen all around the world, people are willing to try some very out there things to stop getting this virus. Potentially this is putting them in a vulnerable state, and so it's unconscionable for this company to take advantage of that and say, look, we've got all the answers, buy this mask from us and you'll be fine. Do we buy that argument, do you think?
Look, I think that's a pretty weak argument for unconscionable conduct. Is my understanding, I guess the threshold for a special disability and unconscionably exploiting a special disability, I just don't think that could be made out on the facts here. I guess we don't have enough information around this, but maybe, say, for example, it could be unconscionable if this was the only pharmacy in a small community that was getting smashed by the coronavirus, and people there were, they didn't really know what was going on, and then this pharmacy was selling masks at $100 each for a rather impoverished community. You could maybe start to build a case around unconscionability there.
Yeah. So on what's sort of available to us, probably not, but if we had more information and it was the right information, then maybe. Yeah. Any other thoughts on that one?
It really draw up to what the actual reaction is and what the intent behind it was. It's just, you need a bit more information behind it, I guess.
Yeah, absolutely. So a bit more of the context.
Like if it had something like limited stocks in times like these, then you can kind of go, all right, what were you saying in that?
So buying into the hype of don't think, just buy one now, that might be sort of problematic as well.
Yeah, because then you can start to draw it up as they're not just trying to sell masks; they're trying to bank off of a pandemic. And use
really
fear that the pandemic's bringing to make money.
Yeah, absolutely. Awesome. All really good points. All right, I might stop that one. Any other thoughts, questions, concerns before we wrap up? Cool. Well, I'll put the recording will go up overnight next morning, and then with it will go a practice question and the examples of the two answers that we've discussed today. Also worth bearing in mind that the assessment 2 question goes up next Friday morning, so the Friday of week 9, that'll get released, and then that's due on the Friday of week 11. So giving us 2 weeks to do that assessment again, rather than just the one, because of all the coronavirus stuff that's still hanging around. But other than that, stay safe, have a good week, and I'll see you all next week to talk about competition law. See you all then. Thank you very much.
Thank you.